Good afternoon. Next case is State versus Washington. We will hear from the appellant.
May it please the court. I'm Assistant Appellate Defender Dan Schatz, and I appear today on behalf of Mack, Washington, the defendant in this case, and the appellant in this court. This is a case presents one issue to the court, the question of whether the trial court erred by excluding the defendant's proffered evidence in the form of the videotape interview with the complainant in this case, the portion of that interview that addressed allegations of abuse against a 15-year-old offender and the reason this evidence was important is because that video showed just a very different demeanor and reaction on the part of the complainant. I plan to address two different related reasons why the trial court's ruling was erroneous, and then talk about why that erroneous ruling prejudiced Mr. Washington, and I would like to reserve 5 minutes for rebuttal. Starting with the plain language of Rule 412, that rule limits its application to the sexual behavior of the complainant. And in no other context would we ever say that the commission of a crime against a victim constitutes the victim's behavior. The victim was there, and that conduct was we think of as being perpetrated on the victim by somebody else. Nobody ever thinks of in any other context as the victim's behavior. And so really the plain language of Rule 412 should answer this question, and the answer should be that the rule has no application to this proffered evidence. This court has never endorsed an interpretation of Rule 412 that includes this kind of evidence. The Court of Appeals has done so, and the case where that happened is State v. Bass. In State v. Bass, the Court of Appeals reached this conclusion without much analysis. They simply stated, we conclude that the prior abuse is sexual activity, quotes around sexual activity in the opinion, within the ambit of the statute. And they cite this court's opinion in State v. Alice. But this court in Alice had never said that. In Alice, this court basically said, assuming the statute applies, one of the exceptions applies.
Do you think non-consensual sexual activity by an adult is covered in sexual behavior? So, for example, a woman who had previously been raped. Is the evidence of that prior rape fall within the ambit of 412?
I don't believe it is, Your Honor. I think the same reasoning would apply in that situation. And so if you go back to this court's opinions in the Younger case and the Fortney case, and these are cases that came out shortly after the predecessor statute to Rule 412 was enacted, the court talks about the reason for the rule, what the prior common law evidentiary rule was, and the prior common law evidentiary rule was that in these types of cases, the complainant's reputation for unchastity was always admissible under what in Fortney this court explained was antiquated reasoning that kind of dates back to when women were thought to either be chaste and virtuous or strumpets who lacked credibility and who would willingly consent. And that's, Fortney uses those words and talks about that. And that, the the Fortney and the Younger cases explain that the statute was enacted essentially to abrogate that common law rule of evidence. And the situation you described, Your Honor, just was never encompassed within that reasoning and isn't what the statute was designed to abrogate. And I don't think there had ever been a rule that sort of thing was generally admissible in all of these cases, sort of on an ipso facto basis. And so in State v. Bass, the Court of Appeals, that's the first time any court had ever said the rule, as a part of a ruling, had said that rule applies to this kind of conduct. And Bass was kind of an unusual case because there were two issues. The first was the judge excluding the evidence, and then the second issue was that once the evidence had been excluded, the prosecutor argued to the jury, well, there's no other way this 6-year-old would know to say these things if it wasn't true. And the Court of Appeals held that argument, even though the evidence hadn't come in, that argument was erroneous. And so if you read the last paragraph of the Bass opinion, it kind of reaches a result that doesn't seem to make any sense, because what it says is that a 6-year-old would know nothing of sexual activity but for defendant's alleged abuse can be fairly implied. The jury could draw such an inference from the evidence before it in this case. Nevertheless, the prosecutor couldn't argue it. So what you have is the Bass Court was okay with the idea that the jury could be given a misleading picture of the evidence that would lead it to draw an inference that everyone who knew the evidence that had been excluded knew wasn't a good inference to be drawn from the case, but that the prosecutor just couldn't explicitly tell them to make that inference. And the idea that the jury can be given that kind of incomplete picture just doesn't lead to a just outcome. And so really there's not a policy reason why we would say, okay, well, the evidence can be excluded, but the prosecutor can't tell the jury what inference to draw from the fact that there's no other evidence that would explain the allegations.
And that scenario only applies to juveniles, right? So in other words, you would not anticipate having an adult where you would say we need to admit some evidence because it explains how this adult could describe, like the birds and the bees type thing.
Right.
You have a situation with young children where you say it's admissible because there'd be no other way for the child to know. That's an argument, jury, and then you would say, but actually, in fact, I think there's cases in the Court of Appeals about watching pornography and other things.
Right. So to get back to your earlier question and kind of tie this together, I don't think the rule keeps that kind of evidence out or applies to that kind of evidence in an adult case, but that evidence is much less likely to be relevant for any other reason. And the rules of relevance still apply. And so that kind of brings me to the other reason, which is the holding in Younger. And the Fortney case mentioned this as sort of an explanation of how the statute works. But in Fortney, it wasn't part of the holding. But in Younger, the court actually said, even though on its face the statute would seem to be written in absolute terms, it was not intended to exclude evidence that would be generally considered of categories that would be considered relevant. So this gets back to, and these were both adult cases. So again, it talks to what would otherwise be relevant. And so in the Younger case, it was really inconsistent statements about the prior sexual activity. And the court held, well, no, inconsistent statements are always admissible in every criminal case, and this statute wasn't intended to be a revolutionary change in the rules of evidence and keep out categories of evidence that would generally be considered admissible in the run-of-the-mill categories of cases. If a victim in a robbery case or a financial crime case gave inconsistent statements about it, it would always be relevant, and it would always come in. And so the Younger case makes it clear that despite the statutory language, that wasn't the purpose or the intent of this statute, and that's not what this statute means and not what it does. And so I think in this case, in the Court of Appeals, the court just didn't quite follow that. So in paragraph 22 in the Court of Appeals opinion in this case, the Court of Appeals recognizes, they talk about what the defendant had intended for this evidence, which was to show essentially a motive to fabricate the identity of the perpetrator. And the reason the evidence, according to the defendant, showed this is because of the child's vastly different reaction when this topic first came up, and the interviewer asked her, "Is there anything else going on with anyone? Has anyone else done anything like this?" And she says yes. And then her demeanor changes. And by demeanor, I don't just mean the physical appearance, but it's also her tone, how she's reacting to questions, what she's saying, the fact that she is just palpably fearful of her mom finding out about this other accusation. We later learn from the voir dire during the trial, or the proffer during the trial when the jury's out of the courtroom, that this perpetrator was somebody living in her father's home. And so, because she says at the proffer, he's gone back to New York, he's no longer in my father's home. So there's some kind of dynamic going on there. And so that was the purpose the defense alerted the trial court. This is what we intend to do with this evidence. This is why we think it's admissible and relevant. And the Court of Appeals, so in paragraph 22 of its opinion, says, they briefly mention that was the purpose, and they say, this would be admissible under Rule 401, but it's constrained by the text of Rule 412. And that's kind of, I think, contrary to what the Younger court said about the rule and the limits of how it applies to evidence. And just like inconsistent statements in Younger, I think having a motive to fabricate some part of an allegation is common to any kind of case. And the holding of Younger fits this evidence, and we think under Younger, this evidence was admissible and should have been admitted. We still, even in the proffer, even after this 15-year-old was no longer living in her father's house, the child still didn't want to say much about it, and still didn't give a name, still never said exactly what this person did to her. So that's also another way of looking at this, that it's not actually involving sexual activity. It's about just the fact that this girl was a victim to somebody else.
So can I just ask you, so are you arguing that even if it is subject to Rule 412, it is nevertheless admissible under Younger?
Well, I think it's not that it's admissible. Younger says the rule doesn't stretch, even though a literal reading of the statute might make it seem that it would. That's not what the statute does and what it says. So Younger says the statute doesn't extend to that, even though the facial language of the statute might seem to.
Because the statute does seem pretty categorical. It says the sexual behavior of the complainant is irrelevant to any issue in the prosecution unless it meets one of the four exceptions.
And so what I think Younger is really saying is that it is no longer automatically relevant in the way it was under the common law before the statute was enacted. Because if you look back to Younger and the Fortney and how they explain how the common law evidentiary rule used to work, that kind of evidence was essentially admissible as a matter of law in every case in these categories. And that's, so the statute has to be interpreted in light of the remedial purpose and what the legislature, the ill the legislature was intending to cure by enacting the statute. And so that is what Younger says about it. It is, so in Younger, inconsistent statements is not one of the four, categories of exceptions under the statute. But Younger said, this is still, a defendant is allowed to present this evidence for this purpose. And so that is what Younger says and what it does in the holding. And so looking in this at the interpreting the statute in light of Younger would say that the statute does not encompass this evidence. And again, in some sense, because there's also, one of the other related reasons as far as why this was error is the defendant's constitutional right to present a defense. And Younger doesn't actually talk about this, but I think sort of baked into Younger is sort of a bit of the doctrine of constitutional avoidance, that the statute can't be read in a way that would prevent a defendant from asserting his defense. And so that's really what Younger says about the statute.
So I want to ask you first, in terms of what you said about effectuating the purposes of the statute, aren't the facts in this case, particularly where the victim said the very reason she didn't want to talk about the 15-year-old was because people would, essentially all the embarrassment, imputation of sort of that she might be inviting this behavior, she articulated exactly the things that the General Assembly was saying, this is why this evidence is not relevant.
Well, she may have articulated something, but nobody is looking at this evidence and making the kind of categorical inferences about her. Nobody thinks this means she's loose or immoral or lacks credibility or any of these things that are so when in Younger and Fortney, they talk about, the embarrassment kind of thing, they're talking about the rule that this was always admissible and the inference that the law made that a woman who would engage in consensual sexual activity was immoral, lacked credibility, and would be likely to consent to have sex with anybody. That's what those cases talk about, and that is the context in which that ill was, the legislature was trying to cure that ill, because nobody, she may have expressed that concern, but that's not, that's not what was baked into the prior common law evidentiary rule that the legislature was making a course change when it enacted the statute.
But if your read is right, then that it was really about the legislature not wanting to, in court documents, have a woman be embarrassed because of consensual sexual activity, wouldn't the legislature have said that? I mean, I think Justice Earle's read is, based on the cases, the legislature said what it said it's irrelevant, described sexual activity, and didn't use the consensual versus non-consensual, so don't we presume then that they're looking to protect this young woman from the exact harm that she articulated?
Your Honor, actually, one of the rules of statutory interpretation is that when the legislature enacts legislation, it does so with knowledge and does so against the background of existing law. So the existing law was that consensual sexual behavior was always admissible. And that's just what this court has said in Fortney and in Younger, that is what the legislature, that's what this court has said was the legislative intent of that statute. So
I'm struggling a little bit to see how Younger is very helpful because, of course, Younger involved prior inconsistent statements, and we can all understand that those could be used to call a witness or a victim's credibility into question. But here, even if we assume that there was another abuser, how is that inconsistent with the allegation that the defendant was an abuser? In other words, the fact there are two abusers, that doesn't automatically mean that, or there are two accused abusers, doesn't automatically mean that one of them is off the hook.
No, that's true, Your Honor, but again, in terms of how a jury is going to look at this evidence, had the jury been allowed to see the entire interview and say, or look at how differently the child reacted when the subject of the other abuser came up, and she doesn't want her mom, she just reacts very differently and doesn't want her mom to know, doesn't want anyone else to know, doesn't want the doctor to have to know, says this person might do something crazy, she's fearful. Again, just the difference in how she presents the accusation. A jury can look at that second half of the video and go, wow, that's, you can just feel the emotion there. That's they can maybe connect with that. And then if you have that and you look back at her demeanor in the first part of the interview, she's very different. She's much more conversational. She's making eye contact with the interviewer. And then I also want, so there's that different presentation. And so I mean, I think everyone in the case is taking the view that what happened with the 15-year-old happened. Nobody is saying that. I don't think anyone is suggesting that was fabricated. But what we do learn in the proffer in the court during the trial is she hadn't intended to say that to the interviewer. She was asked and said, yeah, she was asked, you didn't mean to say that, did you? And she said no. And so then I also want to tie that back to, if you go back to the social worker who interviewed her the day after the accusation was made, and says the reason that she was given for why this was done now is the child had seen a video at school of the importance of disclosure and disclosing, and that's what prompted her to disclose. But that you would think would be an equal reason to disclose if there were really two abusers and two sets of abuse going on, that you would disclose both of those. It may be that the child knew she needed some help and thought she could both keep out this 15-year-old who was living with her father, who there's, again, we don't know the whole dynamic because she never would come out with it, but there's some dynamic going on there. And, she's very fearful of that, but, maybe she needs, from this video, she gets the idea, well, I should get some help. And maybe she feels like she can get the help without identifying the actual perpetrator, where she's very clearly not wanting to do that with regard to this 15-year-old. So there are reasons why a jury can, if they had been given the full picture, might look at the case that way. And, this is kind of the problem. We know that some number of these types of allegations are false. And some are, we'd like to think the vast majority are true, but there's no exact science to figuring out which ones are false, which ones are true, what prompts. And again, keep in mind, we're talking about, the jury should be looking at this through the eyes of how a 12-year-old sees the world. And so it affects the jury's view. The rules of evidence we have a rule of completeness. There's a preference for giving the jury the whole picture and letting the jury figure it out. Let the jury be sort of the human lie detector in the courtroom, is a phrase one of this court's opinions used. And the jury can't do that without getting the full picture. And unfortunately, that's what happened in this case, is the jury didn't get the full picture. So if you just look at that first part, as the jury did, and I would just mention this, they asked to see the video again during deliberations, and they got that same portion of the video. And if you just looked at that portion of the video in isolation, she's conversational, she's articulate, she articulates what she says happened. But then if you just look at how drastically different her presentation and the way she approaches the other allegation of abuse, a jury that had that might think back differently about that earlier portion of the video, which was all they got to see, and easily could have had just a different picture of the facts of this case.
A different picture, but didn't the victim describe kind of a unique condition of your client's genitalia, and then it turned out he has a rare skin condition that makes it look like that, and that is the kind of thing that makes you say, is there any reasonable possibility that the jury would have reached a different outcome, just based on what we're talking about, given some of that evidence?
And the answer is, she actually only gave a partial description, because if you look at, there are two main symptoms of this. One is the dry, scaly skin, which she did describe, but that could be seen. What she didn't talk about were the bumps. And the mother talked about, mentioned this in her testimony, and she said, yeah, there were several bumps, and one of them was particularly large. And given what this girl is saying, she's alleging that he's making her give him hand jobs. There would be, she doesn't ever describe that tactile, the other big symptom of this condition. And so what that means is, what it needs is, she has seen it, she's heard, the parents, the mom and Mr. Washington talked about, the house, there were a lot of people, the kids would come running in the room. There's at least one instance that the mom told the detective about, where the kids came in and pulled the covers off the bed. And she said, yeah, he was trying to turn around and get away, but that doesn't mean the girls didn't see anything. They could, and that's not the only source, they could have overheard a conversation. There could have been a conversation, kids learn more than the parents always, want them to. Kids in a house hear stuff, see stuff that isn't intended for them, and so that's always a possibility. And there was evidence of at least her opportunity to have the visual. And so in that way, the absence of her description of the tactile symptom that ought to have been, or you'd think would be obvious from the conduct she's describing, that was totally missing. You also have the fact that she, clearly gave a wrong timeline when she made the allegation. Even her mom corrected her and said, no, that isn't even possible. And her explanation of it was, well, when I was in the 3rd grade, I was told I have this brain condition. That's not an answer that should inspire confidence in the reliability of her testimony. I see I'm well into my rebuttal time, so if there are no further questions, I will reserve the balance of my time.
Thank you, counsel. We'll hear from the appellee.
Good afternoon, Your Honors. May it please the Court, my name is Kristen Euchre, Special Deputy Attorney General with the Department of Justice, and I represent the state in this matter. Defendant lacks a constitutional right to harass witnesses, and neither of the constitutional rights he has cited here, his right to present a defense or to confront the witnesses against him, are absolute. The United States Supreme Court has stated that in multiple cases. Finsterer and Lucas are two relevant ones to point Your Honors to. The right to cross-examine witnesses is for the opportunity for effective cross-examination, not cross-examination that's effective in whatever way and to whatever extent the defense might wish. And as for the right to present evidence, Lucas says that the right to present relevant testimony is not without limitation, but may bow to accommodate other legitimate interests in the criminal trial process, as long as those restrictions are not arbitrary or disproportionate to the purposes of the rule. Defendant can't simply say, I have this constitutional right and it has no limits and that he can just do whatever he likes. The U.S. Supreme Court has said otherwise, that there are permissible limits to those rights. This court has already held that Rule 412 is such a constitutional permissible limit on those rights. This court did that in Fortney, where it examined the statute in depth, including the purposes for its enactment, and said that it reflects, it's actually a codification of this court's recognition that all sexual behavior is not intrinsically relevant to trials of sexual offenses. So defendant's characterization that 412 is some sort of massive shift or correcting something is not really accurate, as this court said in Fortney. This court had already come to that same realization that not all sexual evidence has intrinsic value in sexual assault trials.
If we accept the state's interpretation of this provision, it means that it was drafted in a way that it defines a woman who is raped as having engaged in sexual activity. It says that a woman who is raped, that is her sexual behavior, which is really troubling. But I take it your response to that is, but it's designed to protect the woman in that scenario from being harassed because of that horrible thing that happened to her. So explain that. How do we get around the fact that we're being required to interpret this in a way that doesn't seem right?
That's right, Your Honor, that because the rule is a rule of exclusion, bringing all of that in operates to protect the victims of that behavior. But I think that it just goes to the plain language. So you're not simply left to determine what sexual behavior is, like in a vacuum, just resorting to normal language. The statute defines what sexual behavior is, and it says it's sexual activity of the complainant other than the sexual act which is at issue in the indictment on trial. So it's a term of art in this particular statute, and it is given this particular meaning, and they took great care to make sure that they exempted the sexual act at issue in the trial, which is, by definition, a non-consensual act.
So there'd be no need for that
Exactly, Your Honor.
if sexual activity didn't also include, or didn't include both consensual and non-consensual.
Exactly, Your Honor. I think also this analogy to other crimes and saying that the victim of other crimes hasn't engaged in the crime is intuitively appealing, but the reason that it doesn't get you anywhere is that you don't say that the person, I think defendant used in his brief, a person who's been shot has not engaged in a shooting, which is obviously true, but those sorts of behaviors are not completed, how do I say this? Sexual activity, regardless of if someone's doing something, not doing something, whether they want it or not, their body is engaging in the behavior. Their body is doing, or it is being done to them, they're being forced to do it, their body is doing the thing. That's not true of those other sorts of crimes, which involve an inextricable element of consent. Like you can't be assaulted other than against your will. You can't be deceived other than against your will. But you can engage in sexual activity against your will or willingly. So I think that's where the difference comes in here. But putting all of that aside, the statutory definition of sexual behavior is what controls here, and it specifically says that, specifically contemplates that non-consensual acts would be included in that definition, other than the one that is at issue in the trial. Because if it didn't say that, then the victim would be presumably prohibited from testifying about it. And so that's the main problem with defendant's plain language argument. He ignores that definition there, and he's just resorting to the normal everyday usage of the words where, in fact, it's a term of art, and this court has said that in those instances, the legislature's definition controls. And Justice Dietz, your point was well taken about non-consensual sex with an adult. Wouldn't that be covered by 412? And I think that is the exact right question here, because defendant's interpretation here would swallow the entirety of Rule 412. If the defendant could bring up any sort of sexual behavior, whether it's consensual or non-consensual, and say the behavior itself is not relevant, but simply how the victim reacts related to that behavior is relevant, he's bootstrapping relevance where there is none. And this court has already recognized that sexual activity is not intrinsically relevant in these cases without something specific to tie that sexual activity to the issues in the case. The ones that have been put before this court have been to explain physical findings, to show inconsistent statements that were made, or to show false allegations of prior sexual abuse. And none of those are at issue here. There were no physical findings, and there was, defendant has never made any allegation that the defendant, or the victim, I'm sorry, has made an inconsistent statement or a prior false allegation. The Court of Appeals statement in this case that Rule 401 allows the admissibility of this evidence, but 412 does not, is not correct, simply because as this court found in Fortney, sexual behavior evidence is not intrinsically relevant, so it can't even pass the rule. Well, Rule 401 is not even a rule of admissibility, it's a definition defining relevance. So for that reason alone, it's an incorrect statement. But moreover, there's simply no logical connection between these two different sexual assaults, and so it cannot even meet the definition of relevance. And by defendant's logic here, he keeps talking about how sexual behavior had been used in the past to show consent in rape cases, which is certainly true that it was used in that way. But to say that that is the only impermissible use for sexual activity evidence is not correct. This court in Fortney recognized that that negative inference extends beyond even consent and just to the witness's general credibility. This is from State v. Fortney, and this is on page 40, near the top. It says, many courts apparently extended this thinking to include the notion that unchaste women were especially prone to lying. And it continues to say, common sense dictates the unreasonableness of this attitude. If sexual experiences outside marriage render one woman less truthful than her virgin sister, then sexual experience outside marriage would be an issue at any trial where a woman was a witness. This is plainly not the case. So this court has recognized that bringing in other sexual activity serves to just generally lead to this impermissible inference of lack of credibility, and that is what Rule 412 is aimed at. And to hold otherwise would mean that 412 would only apply in instances where consent was at issue. And plainly, that's not the case. The statute specifically says in subsection D, I think it is, that Rule 412 applies to trials for the listed offenses. It doesn't say only trials where consent is a defense. It says it applies to these trials. I just want to go. Even if this court is not convinced by the plain language argument, which that should settle the matter, but if it doesn't, the statutory intent also is in favor of excluding all evidence of sexual activity, whether it is consensual or non-consensual. As Justice Earls was mentioning, the purpose of 412 is to avoid harassing or humiliating the witness, and which means having people think that she wanted this behavior to happen to her, and all of that is just as at play in non-consensual sexual acts as well as consensual sexual acts. In Lucas, the U.S. Supreme Court called that rape shield law a valid legislative determination that rape victims deserve heightened protection against surprise harassment and unnecessary invasions of privacy. It is a valid purpose to curtail even relevant evidence, and here the evidence is entirely irrelevant, as well as contains no probative value, and exposes the victim to all of those negative consequences that that Rule 412 was designed to prevent. And I think even more fundamentally here, defendant hasn't shown any error of law in the Court of Appeals opinion. He's talked with this court about Bass and how it relies on Aulis, but even assuming that Aulis doesn't support what Bass says, that proposition is not incorrect for all the reasons that the state has argued here. The plain language of the statute and the statutory intent, it's clear that 412 does prohibit or does bring into its definition non-consensual acts, which then means that those acts are also prohibited from being admissible in these cases. The Court of Appeals cases that defendant cites in his reply brief about out-of-court demeanor evidence are clearly different from what is involved here, because those are about the child's demeanor in discussing the acts that are at issue in the prosecution, not totally separate ones unrelated to the acts that the defendant is on trial for. Defendant does not argue that the evidence itself was relevant, that the evidence of the abuse itself was relevant in any way in his brief. It seemed like he might have been trying to make that argument here, but in his brief he merely said that the demeanor was what made it relevant, which that cannot be, you can't create that, you can't manufacture relevance where there was none to the information that she was conveying while she's displaying the demeanor. And I think to go to the prejudice a little bit, the victim did describe the tactile sensations of the defendant's penis. She described it as crusty and scaly. The defendant's attempt to say that she could have seen that is not plausible. The victim's mother said that the defendant would have immediately covered himself up. The other children didn't see anything. They don't know anything about the skin condition that defendant has, as well as the fact that the prejudice is what was lost to him by not being able to introduce this evidence, which he says is merely this change in demeanor, which does not show anything. It doesn't show that she has any it doesn't show anything inherently about her credibility. It doesn't show anything about whether these acts did or didn't happen. All that happened was he was prevented from showing this juxtaposition of these two different demeanors. And in fact, the victim's demeanor was quite thoroughly discussed. Obviously, the jury was able to view the victim's demeanor while she's testifying and while she was being interviewed on that taped interview. But then there were also multiple instances where people testified about how she was behaving throughout this investigation. The ER doctor mentioned that she was pleasant and cooperative and overall well-appearing. The victim's mother said she was very calm when she took her to the police station to report the abuse the same day. That's on page 134 of the transcript. The victim's father, said that the victim kind of broke down a little bit at the hospital and that it was a hard situation. And he also said that while during this period of time, the victim would often be down and sad, and when he would ask her what was going on, she would say, "Oh, defendant is back," and that's on page 198. The social worker also mentioned that she started crying when the victim was talking about how the defendant put his penis inside of her vagina one time. That's on page 222 of the transcript. These are all instances where defendant had, even within those, contrasting demeanors from which he could have drawn some sort of conclusion or inference if he had chosen to do that. This inference, or this particular demeanor, is simply not relevant because it is not, the information underlying it is not relevant. So just to wrap up, the defendant's constitutional rights here are not absolute, and Rule 412 is a non-arbitrary and proportionate limitation on those rights. He had the opportunity to show specific relevance. He failed to do so. He cites only that the demeanor of that information was relevant, which is clearly not true, as well as so far removed as to be clearly outweighed by the prejudice to subjecting this child to re-victimization on the stand. And then under 412, the plain language of the statute says that sexual activity with no regard to whether it is consensual or non-consensual is out. The state respectfully asks this court to affirm the Court of Appeals or hold that discretionary review was improvidently allowed. Thank you.
Thank you, counsel. Rebuttal.
I want to make two quick points about additional reasons why this evidence was relevant that you didn't get to in the opening argument and kind of in response to what the state said. And one is, when the trial court made its ruling, it said, I'm also going to prevent the state from introducing evidence of therapy, cutting herself, trauma. But that evidence came in and the jury heard it. And the judge gave a limiting instruction to some of it, but there were still other evidence of symptoms that a jury heard that could be easily be, when they're only hearing about the one accusation, would assume that corroborates that accusation, where we can see from her demeanor that the other accusation seems to be more like it creates just a physical reaction in her, that a jury, had they seen that, could attribute whatever trauma this girl was suffering to that incident. And so you had, the mother and the father both talked about that. The judge gave that limiting instruction, but as this court has recognized, sometimes a limiting instruction, you can't unring the bell with the jury. And so I know as a parent, if I heard evidence about a kid cutting themselves, there's no way I'm going to just be able to put that out of my mind. The other point I want to make about that in terms of relevance is the DA in this case made the same kind of argument as the DA in Bass. That she said, kids don't make this up. And so after the prosecutor's argument, the defense renewed their objection to the exclusion of this evidence and said it would have been responsive to that argument. And so for these reasons, we think the evidence was relevant. The trial court erred by excluding it, and since I'm out of time, I will simply ask this court to reverse the court below.
Thank you. Mr. Clerk?